Hello everyone. I hope this message finds you fit and fine. In our journey of Indian Constitution Part 3, today we are at Article 32. We are going to complete 32, 33, 34, 35 and that's how Part 3 of Indian Constitution will be completed. Okay. Now, Article 32 talks about constitutional remedies. Remedy, it means solution. So when you talk about solution, you only talk about solution when there is some problem. So what kind of problem we may face related to Part 3? The biggest problem is the fundamental rights which are given to us. We need to protect them. So it means problem is state or private individuals in some case, they may abridge your fundamental right? So we need to give you certain tool to protect yourself and that tool is Article 32. Okay, that's why we are using the word remedy, solution to this problem of fundamental right protection. Okay, now Dr. B.R. Ambedkar, he made a famous statement regarding Article 32. He called this provision as heart and soul of Indian Constitution. Such is the importance of Article 32 because Constitution establishes relationship between citizens and state, means government. So now every relationship is based on rights which you can claim in that relationship. How this relationship is going to let you utilize your potential to the, you can say, maximum extent, right? So in that case, this is only possible when you are given certain rights and there is a tool given to you so that you can protect those rights, right? Otherwise, the legitimacy, the value of fundamental rights would have been decreased, right? Now, Supreme Court has ruled that Article 32 is basic feature of Indian Constitution. You are well aware of Kesavanand Bharati case as we discussed in previous classes, right? So now Kesavanand Bharati case talked about basic structure doctrine. My friends, don't take this particular sentence lightly because a beautiful statement can be made and many students are going to get trapped into it. For example, as per Kesavanand Bharati case, Parliament has power to amend any section of fundamental right. Because there was a debate going on whether fundamental rights can be amended or not. Kesavanand Bharati case said, yeah, you can amend fundamental rights, but you cannot touch the basic structure, change the basic structure of Indian Constitution. Now, in that context, can Parliament make a law to remove any of the writs which are given? Writs means power of Supreme Courts to actually issue some legal order. So, writ means legal order. Okay, and this power to issue legal order by Supreme Court regarding fundamental rights is mentioned in Article 32. Okay, so now Parliament cannot take away any of those writs because now Article 32 is considered as basic feature of Indian Constitution. Okay, you cannot abridge it. Supreme Court has been constituted as the defender and guarantor of the fundamental rights, and which article expressively means, you can say, from which article Supreme Court draws power to judicial review? Article 13. We talked about it. Now, you can simplify Article 32 by understanding 4 provisions which are mentioned here. Okay, there are 4 provisions which are given in Article 32. Number 1, right to move Supreme Court, because this is the first step now. Purpose of adding Article 32 is when your fundamental right is abridged, right? Or possibility you are thinking that it is being abridged. So in that case, you can move to Supreme Court using Article 32, right? So it means you are here and you move to Supreme Court. This is the first step. This is a way to remember actually these provisions. Now, Supreme Court should be given certain powers, right? So that Supreme Court can actually protect you. So this is step number 2, or you can remember it, this is actually provision number 2. Okay, the Supreme Court shall have the power to issue direct orders, writs. Okay, and what are those writs? Habeas corpus, certiorari, prohibition, mandamus, quaerentur. We are going to talk about it. So it means this is the second step. Then only your rights can be protected. So these are the two clauses. Now, third clause. Parliament can empower any other court to issue direction, order, writs of all kinds. Now, when it is saying all kinds, it is specifically talking in context of constitutional remedies. Now I'm making a statement and you have to tell me the statement is true or false. Article 32, subclause 3 allows Parliament to give power to issue writs, power or extend the power of writs to High Court. Full stop. Now tell me that statement is true or false. I am repeating my sentence. As per, you can say, as per Article 32, Parliament has power to give power to issue writs to other court, in this case, High Court. My friends, the point I want to make is that this subclause C is not related to High Court. Okay, it is not related to High Court. The reason is because High Court already has power regarding fundamental rights using Article 226. Then why would have constitutional framers added third clause and referring this any other court as High Court? Right? So it means this any other court here is not High Court. Okay? It means it represents court beyond Supreme Court and High Court. I hope this intricacy is clear to you now, right? Because these are the intricacies where UPSC play. Now, Constitution provides that President can suspend the right to move any court for the enforcement of the fundamental rights. And you are well aware, we are talking about Article 32, and Article 32 is giving you this power that you can go to Supreme Court, right? Now here, this provision is saying that this particular right can be taken away, right? In what case this can be taken away? For example, in case of national emergency, we are going to deal with national emergency as a separate chapter, but you should remember, in case of national emergency, your right to move Supreme Court for fundamental right can be taken away. Okay, but can it be taken away ipso facto? Ipso facto means automatically. No, that's not true. Okay, a separate order may be issued in this regard. We are going to discuss this. Okay, now purpose. What is the purpose of Article 32? Purpose kya hai? That these fundamental rights are guaranteed, effective, expeditious, and inexpensive. The purpose was this: protection to only fundamental rights and not other rights. For example, non-fundamental constitutional rights, statutory rights. I am giving you another example. Consider you are given a right through a law made by Parliament. Then that right will be considered as a statutory right or legal right. Why it's statutory right? Because it is made because of the statute which is passed by Parliament. Now, if this right of yours is abridged, can you knock the door of Supreme Court using Article 32? No, because Article 32 is mentioned in Part 3, which deals with fundamental rights. Okay, that is why this service of Article 32 and Supreme Court is available only in case of fundamental right. And in this context, you should also remember the statement which was made by ex-CJI, Mr. S.A. Bobde. So what he said? He said, Article 32 should be used by people only when other alternatives regarding they ensuring their fundamental rights, they have used those alternatives. And then they should come to Supreme Court as a matter of last resort. At this point, there was a huge debate in news. Several articles were in news and he was criticized too, that this is a right given in Article 32 and this Article 32 has not mentioned this. First you have to move in other courts and then as a last resort you can come to fundamental right. Then you can come to Supreme Court to ensure these fundamental rights, right? So there was a debate in this. Okay. Now, jurisdiction of Supreme Court, Article 32, and jurisdiction of High Court, Article 226. Now, I am making another statement. Okay, and you have to tell me the statement is true or false. I am saying the territorial jurisdiction of High Court regarding usage of writs in fundamental right is more than Supreme Court. Simply saying, let me simplify this statement for you so that you would not forget. I'm saying when it comes to High Court, so High Court's territorial jurisdiction regarding fundamental right, writs, means writs used for ensuring fundamental rights, is more, or you can say larger than Supreme Court. Than Supreme Court. And in case of Supreme Court also, we are talking about territorial jurisdiction. And you have to answer me in true or false. Okay? Obviously, when we are talking about writs for Supreme Court issues writs only for fundamental right. Now, tell me the answer is yes or no. Come on. My friends, answer is no. You know why? Why yes is wrong? Because we have used the word territorial jurisdiction. Territorial jurisdiction means territory, extent of the territory to which High Court can actually have power of its writ, its legal order. Okay? So you should remember this, because why I am mentioning this, because there can be another question. I am going to make another question, and sometimes students get confused in these two dimensions. First of all, take case of say Allahabad High Court. So you belong to Madhya Pradesh, okay, and there some of your fundamental rights are abridged. Now tell me, can you go to Allahabad High Court saying, although I belong to Gwalior in Madhya Pradesh, but I'm going to exercise my right mentioned under Article 226, and it allows me to go to High Court. So I choose to be in Allahabad High Court because I have some friends here. Then Allahabad High Court would say, okay, sir, go back to your home state and apply, file a petition in your High Court. The reason is because Allahabad High Court's territorial jurisdiction with respect to the writs used in case of fundamental rights is restricted to that particular state only. That particular state only. Okay? But when it comes to Supreme Court, if Supreme Court is actually issuing an order, then this will be applicable to whole India. Okay? Now, second dimension. Second dimension is High Court's power or scope of usage of writs is more than Supreme Court. When I am saying Supreme Court, I am talking about power scope, basically power in context of scope. And when I am saying scope, it means in how many cases, how many type of cases this scope of writs is going to be applicable. Okay? Now tell me, the answer would be yes or no. Come on. Now here answer is yes. You know why? Because in case of High Court can use writs to protect your fundamental right as well as your statutory right, or you can say legal rights. But when it comes to Supreme Court writs as mentioned under Article 32 can be applied only in case of fundamental right. So it means scope is more in case of High Court, means variety is there. Variety hai. But kahan tak ye variety chalegi? Till what extent this variety will be applicable? Only to that state. So word territorial jurisdiction and scope, it should be clear in your mind. Okay? Now, take this table, and I hope this is visible to you on your screen. So this is taken from Lakshmikant. So you can open your Lakshmikant simultaneously and just take a look. on the table. The differences between Article 32, Article 226. I've just explained this to you. Article 32 is applicable in case of fundamental rights only. That is scope. But when it comes to 226, it is applicable to constitutional rights. Means it is for fundamental rights as well as statutory rights. Statutory rights can also be added. Suspension. Article 32 can be suspended if emergency has been declared by President. Just mentioned this with you. Now, 226 cannot be suspended even at the time of emergency. Means, because now you should think that when I'm saying Article 226 cannot be suspended even at the time of emergency, it does not mean that you should look at this statement only in context of fundamental right. We are using this Article 26 cannot be suspended because there can be many legal rights. And presidential order, which is issued at that point of time, we are going to talk about Article 358, 359 in emergency chapter. It is specifically deals with fundamental rights. Okay, so legal right aspect is not there, when it comes to emergency in case of High Court. That is why this particular statement has been made. Now, Article 32 has a narrow scope, just told you, and Article 26 has a broader scope, fundamental right, legal right, both, right? This is clear to you. Jurisdiction. Article 32 empowers empowers Supreme Court to issue writs all over India, just told you. And this is local jurisdiction. Local jurisdiction means specifically in context of state, like Allahabad High Court, UP, right? Discretion. Since Article 32 is a fundamental right, the same cannot be refused by the Supreme Court. Article 226 confers discretionary power to the High Court, which means that is it at the discretion of the High Court to issue writ or not. Okay, but in this case, Supreme Court cannot refuse this particular, you can say, petition if the points are valid. The reason is because it is mentioned in Article 32, and Article 32 is mentioned in Part 3, right? So it means core responsibility of ensuring our fundamental rights is on Supreme Court, not on High Court. Okay, because High Court power is out of Part 3, mentioned out of Part 3. Okay, so this difference need to be clear with you, because there can be a statement in exam. Okay, now type of writs. So these are the 5 types of writ. First of all, habeas corpus. So it's a Latin word. It means you may have the body. It simply means that, consider there's a student with the name Rohit. Police came at Rohit's door last night, and Rohit was actually detained. So police said that we are arresting Puneet because we have some proof that Puneet has committed some crime. Okay, so it means it was a punitive detention, right? But when the some friends, they reached in the morning the police station, police said no, we don't have Puneet or we don't have Rohit. So in this case, you can go to Supreme Court using Article 32, that detention of Rohit is illegal, is arbitrary. And you can ask Supreme Court, please issue this writ of habeas corpus so that body, means person, Rohit, can be produced in court, and police can be asked question on what grounds you actually arrested Rohit. Do you have sufficient ground or not? So that investigation can now start in that particular process. So don't you think it is important so that the arbitrary action of government machinery can be, you can say, put to a check, right? And you should also know that habeas corpus can be applicable in public as well as private detention. Okay, public as well as private detention. What does it mean? It means if you are detained, or someone is detained by government authority, then also you can go to Supreme Court. If there is private detention, right? So in that case also habeas corpus will be applicable. So to release a person who has been detained unlawfully, whether in prison or in private custody. Okay, now some of you might be finding it interesting why private custody word is used, prison. Because when prison is used, so in case of prison, there are official records. Okay, this person came in prison at this point of time, and these were the people who actually brought this person to prison. But it may be possible that you were not lodged into prison. you are at some unknown location, no official record at that point of its present, and in that case also habeas corpus can be used. Okay. Now, mandamus. So mandamus word means command, to command. Let me explain this to you in an interesting manner. First of all, it is command, certiorari, to be certified, prohibition, to forbid, covenanto, what's your authority. So what does it mean? Let's understand through these interesting cartoons. Now, habeas corpus is a Latin for to have the body, like we were asking for the body of Rohit, is used to secure a person who has been detained unlawfully, illegally. Please remember, unlawfully, illegally. Okay. It's not like if that person is legally detained and you think, no, that's my brother and he should not be arrested and you can go to Supreme Court. No. In that case, your petition will not be accepted. Okay. Unlawful, illegal should be the basis. Now, take this example. Your Honor, my client has been detained illegally. I'm here to ask for his body back. So, writ of habeas corpus has been issued in this regard in front of this judge. Now, judge will issue this direction to the respective department that you have to produce the body on such date in front of us along with the grounds on which you arrested that person. Writ of habeas corpus can be issued against both. It means public authorities as well as private individuals. Okay. For example, if you are a contractor and you have some bonded labor, and these bonded laborers were demanding that they should be released now. Although having bonded labor is itself illegal, but now you have, you can say, put them in some custody. So in that case, this habeas corpus writ can be exercised against you as well. Now, writ mandamus. Mandamus, we command. Just connect. Mandamus means command. Okay. So when command is given, so that someone can perform that action, right? Take this example that one government authority, some officer, has to perform some task for you. Okay. Consider that your grandparents, okay, and they have retired and now they want to start their pension. But the person in Treasury office is demanding bribe. And since your grandfather was so upright, your grandmother was so upright, they were saying, no, we are not going to give bribe and we want our work to be done. We have given our whole life to this government service and this is my entitlement. I have contributed to in this. So now this government officer has made some, fraudulent, you can say, reasons to object the file altogether, and this is creating a livelihood issue for your parents, so for your grandparents, right? So don't you think it is against their right to life as well, because their medical supplies, right, they have to take medicines and they have to go to doctors, so their treatment is actually being compromised due to not issuing of this pension. So in that case, if they go to the Supreme Court using Article 32, then court will issue a letter to that concerned Treasury officer that you have to come to Haveli. Where is Haveli? Supreme Court is Haveli, and वहाँ पर आपसे होगी बातचीत. Means we are going to ask on what grounds you stopped, and we command you to actually get this done. Okay. So in this case, please remember, it is not necessary that they will call you up into the court. Okay, it is not necessary. Okay. For example, in habeas corpus, the department has to produce the body because the body is the issue. That person is the issue. Person in custody is the issue. But in this case, mandamus, a simple direction can be issued on the basis of proofs which you have provided, and that particular person, particular authority will be given a command that you have to perform this task. Or if you don't perform this task, give us a suitable reason within this time. So in this way, mandamus writ work. So take example. Your Honor, police is not taking my complaint. Aggrieved individual. So now we order you to take complaint. Writ of mandamus is used. Means order, command, because this is your duty. So now what police is saying? Sure, sir. Public authority. So please remember, mandamus can be issued only against public authority. In habeas corpus, I told you, public authority as well as private individual. For example, I gave contractor, right? Now, why only public authority? Easy way to remember is, mandamus is used when a public authority is not doing a set duty. Okay. Now, my friends, can you actually give this command to a private company? No, you cannot give this command to a private company, because private companies work is not fixed by the process made by government. Okay, they have some independence to perform their task. So this is applicable only on public authority. Writ of the mandamus cannot be granted against private individuals or organizations. Okay, I hope this is clear to you. Now, writ of certiorari, it means to certify. It means to be certified, is issued by the higher court to some inferior court, and please remember, the word transfer is used here. It means, take example. So this is a lower court, and this lower court has issued a direction, that issued a judgment, we give you life imprisonment. And this person is saying, oh no, zindagi khatam. But this person's advocate said, this particular judge and this particular level of court does not have suitable authority. And there is a case of error of law. Means proper law has not been applied. In this case, the law which is used by the concerned judge is not applicable. There is error of law. So in this case, the advocate of this person can go to higher court. When I say higher courts are Supreme Court and High Court, right? So now higher courts will say, hey, lower court, we want this case to be transferred to us. So please remember, in case of certiorari, there is transfer of case because higher court says that you are not capable because you have done these mistakes. So we are going to look into this matter. So writ of certiorari is issued to the grounds, on the grounds of excess of jurisdiction, means you have gone beyond the periphery. For example, say tribunal word is used. So consider example of NGT, National Green Tribunal. Now due to a pollution from a factory, industry, so now what happened? Some people have said that due to this pollution, our life is under threat and some people have got cancer. So NGT is listening to this case, listening to the argument, and now NGT is proposing that we are going to have some criminal action against the industrialist. So now, my friends, when you read NGT's provisions, so you will find that NGT cannot deal with criminal matters. NGT can also look on environmental aspects. In criminal matters, the matter need to go to sessions court, right? So if NGT try to play on these provisions, then this particular case can be transferred to higher court because there is an error of law, or you can say excess of jurisdiction, lack of jurisdiction. Okay, I hope it is clear. Now many students remain confused between certiorari and prohibition. Prohibition is to forbid. Means to forbid. It is issued by higher court, means in this case also it was issued by higher court to the lower court. In this case it is also being issued by higher court to the lower court to stop the law court tribunal from exceeding its jurisdiction. So now what is the difference? Look at the difference. By the listening to all the facts and arguments, lower court, writs of prohibition is saying, hey lower court, we forbid you from deciding anything on the matter. It means here judgment was made, life imprisonment, done, and this person is like, oh no. But in this case, judgment is not made till now. Okay? Judgment is not made till now. In this case was transferred to the higher court. But in this case, there is no transfer of case from this court to this court. Okay, no transfer of case is happening. So it means judgment was made there, no judgment was made here. Case was transferred there, no case is transferred here. Okay. Hey lower court, we forbid you. So writ of prohibition is not available against administrative or legislative bodies, private individuals or organizations. Please remember, this is applicable only on judicial bodies or quasi-judicial bodies. Okay. Now, writ of coranto, last writ. Coranto means by what authority you are on this position. Take example of Rohit. So in the first example, we said Rohit was arrested. Now days of Rohit have changed, right? Now Rohit got appointed as a civil servant. He cleared UPSC and he is appointed as civil servant. And when he was about to get retired, so his time period is gone. Time period is done. He should have been retired. But he is still on this position. And why he is still on this position? Due to some kripa of concerned minister or prime minister, some political people. Now, some junior of Rohit, he is jealous and he is saying that I am jealous on legal ground. That by law, Rohit should give up his position? Because there is no extension letter issued from the date he should have been retired. If there is some extension letter issued by government, then it is fine. But there is no extension letter in record, and yet Rohit is working on this position. So by what authority Rohit is functioning on that position? So that jealous colleague, he can raise this issue in court. Public office, writ of courant. By what authority are you holding this office? Now, High Court, look at the expression of Higher Court. High Court is saying, just Rohit, just explain us. कानून का मजाक बना रखा आपने. You should have an extension issued and then you should have continued on this position, right? The writ requires the concerned person to explain to a court by what authority she holds the office. Okay, so I hope it is clear now. Now, this was Article 32. Now we need to talk about Article 33. So Article 33, Constitution, Armed Forces and Fundamental Rights. Now, do you think the kind of fundamental rights we have discussed in Part 3 are equally available to the people who are part of armed forces or police forces? Answer is no. You were quite happy reading Article 14, 15, 16, 17, 18, 19 and all. For example, Article 19, Subclass 1, Subclass A. You have freedom of speech and expression. But if you are an army person, you don't have equal freedom of speech and expression. Now, some of you might think this is wrong. No, you should understand the reason why this was made. And so that sanctity of this law is intact, so that army person not knocking on the door of Supreme Court that my freedom of speech and expression is being compromised. That is why Article 33 was mentioned in fundamental rights. So first let's talk about Article 33. So it empowers only the Parliament. First of all, you should remember only the Parliament. Okay, state legislature cannot draw power from Article 33 to restrict or abrogate the fundamental rights of the members of armed forces, paramilitary forces, police forces, intelligence agencies, analogous forces. And no state legislature can actually make this law. And why this is made? Take this example. This is Indian Army, Indian Defence Forces. Here you have Pakistan, here you have China, and here they are standing strong, rock solid, main hoon na, right? Now, do you think if right to strike is allowed to the army people, if right to form association, right to engage with media freely is allowed to army people, don't you think it could create a lot of problem? If right to strike is allowed, if army is on strike, what is going to happen with the security of India? Consider for a 1 day or 2 day, the police forces in your area, they say that we are going on a strike, we are not going to be on work. Don't you think your life, our property, everything will be compromised? Right? And we cannot let it compromise. And that is why Article 33 is important. Objective is ensure the proper, there should be, duties should be maintained because these are essential duties, and the maintenance of discipline among them. There was a case, I think 2-3 years back, when a BSF person, he made a video and that video was circled, was online that there's bad treatment of or bad quality food is given to these people, right? And he was making some claim against our Prime Minister. So action was taken, disciplinary action was taken against that person. So many people were actually getting emotional in that point, no action should have been taken, he has raised valid points. My friends, points are valid and these grievances need to be resolved. But the point is, if these kind of things start happening, apprehensions start circulating, and they go on a strike, and there is indiscipline, then our borders will not be secure, our internal area will not be secure. And that is why some fundamental rights are not allowed to them. That's a choice they make. And we should respect them for actually giving up this fundamental right. We should respect them. Those who are not aware of this, then your respect should multiply. But the point is, this country can only prosper, can only run when laws are followed. And not just by army people, by everyone. Right? But the point is, this is what Article 33 is saying. This is the objective expression. Members of the armed forces also covers please remember, also covers those people who are in non-combatant position. It means if a person is hairdresser, cobbler in army, yes, there are. So they cannot say, since I am not in combatant position, I can go on strike. No. It means mechanics, cooks, chokidars, bootmaker, trailer, everyone comes under the provisions made by Parliament, drawing power from Article 33. Because laws are made by Parliament. Some example of these laws: Army Act 1950, Navy Act 1950, Air Force Act 1950, Police Forces Restriction of Rights Act 1966, Border Security Force Act. So all of these laws are made by Parliament, and in these laws they specifically mention what cannot be done, what kind of rights are not available. Okay, those impose restrictions on their freedom of speech, right to form association, right to be members of trade union, political associations, because they have to be neutral, right to communicate with the press, right to have public meetings and demonstrations. 2-3 years back, there was some conflict between some people from Delhi police and some advocates in Tees Hajari court. So some policemen, they actually gathered near this Tees Hajari metro station, and they were raising slogans against Delhi police commissioner, that this is disrespect of Delhi police people, that some advocates get entangled with, and there was some beating there. So at that point of time, this particular incident was actually, you can say, read in context of Article 33. What wrong can happen if such things go on? Now, Article 34, martial law and fundamental rights. What is martial law? Martial law means a temporary provision where civil administration collapses, and in this case, military takeover. So that is martial law. So our constitution says restriction on fundamental rights while martial law is in force in the area within the territory. Now, what kind of restrictions are going to happen? For example, the courts you have as of now will not work in case of martial law. Every part of administration will be taken over by martial law. Now, please remember, this is different from emergency. In case of martial law, it is in specific area, first of all, right? Second, it is temporary, okay? It is temporary. In case of emergency, there is change in relation of sentient state, right? But this kind of changes doesn't happen in case of martial law, right? So the expression martial law not being defined anywhere in the constitution, but emergency provisions are defined in our constitution, Article 352, 350, 360, but martial law has not been defined, okay? Article 34 empowers the Parliament to indemnify, compensate any government servant. For example, you are a part of military and you are posted in some unstable area in Manipur, right? And there is a martial law in place. Consider there is a martial law. Martial law is at last stage, okay? Now you have committed some actions, and through those actions, some fundamental rights of people have been abridged. So in that case, can some action be taken against you? So this particular Article 34 gives you a protection layer on the actions which can be taken against you. Okay, so it means for act done by him in connection with the maintenance, restoration of order in any area where martial law is in place. So in this case, protection will be given. The act of indemnity made by the Parliament cannot be challenged in any court, because Parliament has made the law, you cannot challenge it. Okay, because Article 34 gives this power to Parliament. So now Supreme Court held that the declaration of martial law does not ipso facto. Ipso facto means that very fact, ऐसा नहीं है martial law लगा तो all the fundamental rights will be abridged. Okay, there will be an express order in which fundamental rights, how this matter will be dealt, will be expressively mentioned there. Now, the declaration of martial law under Article 34 is different from declaration of national emergency, Article 352. I have just explained you the difference. This is the difference. It is visible in your Lakshmikant. Please open the Lakshmikant. As you read, you will understand. As I told you, in a specific area, martial law can be placed. But when it comes to national emergency is applicable in all India, or certain areas of India can be actually kept out of national emergency. You should not remember, oh, it's a national emergency, it means it will be applicable in all over India. No, there's an exception there. For some parts, national emergency can be kept aside. Now, affect certain fundamental rights. This part we are going to take in the next video, as I am receiving some signals from outside. So, see you in the next video then. Take care. This needs to be covered.